Welcome to Lesson 1.6, Understanding Legal Systems and Related Laws, Part 2. In your Candidate Information Bulletin, we are in the Security and Risk Management domain. We are in Key Area of Knowledge D, which is Understand Legal and Regulatory Issues that pertain to information security in a global context. Our topics are going to include intellectual property law, computer crime, and cybercrime. So we're going to start by talking about intellectual property law. Intellectual property, often abbreviated as IP, describes a wide range of property that's created by musicians, authors, artists, designers, or inventors. And the key word here is that it's been created. It's your own property. You created it from your own intellect, so something that you created. Intellectual property can be used in commerce, or it could be an artistic or a literary work. Again, it's just the key is that it's something that you created. Intellectual property laws are designed to protect both use and misuse. So who can use it, who's going to get compensated for it, and how it cannot be used. That's our misuse. Intellectual property law includes a number of very specific components, including patents, trademarks, copyrights, trade secrets, and software licensing. And we're going to take a look at each one of those individually. So starting with patents. Patents are designed to protect an invention, something very specific that you can actually create. The invention must be novel, not obvious, and provide some utility. A patentable invention must be something that can be produced. A patent is good for a specified period of time. For all participating members of the World Trade Organization, the WTO, which is administered by the United Nations, a patent is good for a period of 20 years. Copyrights are very different than a patent. A copyright covers the expression of an idea rather than the idea itself. Now, the idea itself, which is something that can be produced, is protected by a patent. A copyright is just the expression of the idea. The intent of a copyright is to protect artistic property, such as writing, recording, or a computer program. The protections are intended to allow the creator to benefit from being credited with the work and to control the distribution, the duplication, and the use of the work. Copyright protection is weaker than patent protection, but the duration of the protection is considerably longer. Copyrights are good for the entire life of the creator, plus 50 years, up to 100 years, really depending on what the item is that's being copyrighted. You don't have to register a copyright, although you can. All you need to do to communicate a copyright is to either put the copyright symbol, which is a C in the 0, or put the notation that this item, whatever it is, the song, the written document, is copyrighted. And you can put that right in a footer or a header. Trademarks are intended to protect a recognizable name or an icon, shape, color, sound, or any combination that's used to represent a brand, a product, a service, or a company. So it's the recognizable image, if you will, or icon of an organization. If you think about Coca-Cola, you immediately think about the colors, the words, and the script. That's a trademark, and that's protected, that you can't start your own company and use different words, but use exactly the same colors and scripts because it may be confused with Coca-Cola. So it's how we protect those images, if you will. Trademark law creates exclusive rights to the owner of the marking that the public uses to identify that company, the brand, or the product. Now, there's a number of different symbols. You might see the R in a circle, and that's used to indicate a registered trademark. You can register a trademark with the government. TM in a superscript is used to indicate an unregistered trademark. It still has the force of law behind it, but it hasn't been registered with the government. And a service mark, which is the SM in superscript, is used to identify a specific service. So rather than the trademark, which is the image or icon, if you've given a name to a particular service, you can service mark that name. A trademark or service mark can be renewed every 10 years. So if you've registered it, it can be renewed on a 10-year basis. Trade secrets refer to proprietary business or technical information or a process or a design or practice that are confidential and critical to a business. Trade secrets don't require any registration, and they actually remain the only legal control for intellectual property to remain undisclosed. When you create a patent, you file a patent application, and that patent becomes public knowledge. Your trademarks are obviously designed to be public. They're your public image. Your copyrights, because you're distributing the information in the public, again, is designed to be public. But a trade secret is something that you have, your organization has, that you want to protect, that you're not putting out in the public. It's the complete opposite of that you want to have remained undisclosed. So trade secrets you want to have remain undisclosed. But an organization has to take reasonable steps to protect its secrecy. So the legal protection for a trade secret does depend upon the jurisdiction. In some jurisdictions, legal protection for trade secrets is perpetual and does not carry an expiration date. So here, the key difference with trade secrets when all the other intellectual property we looked at is this is the one that remains undisclosed, and an organization must prove that it has taken steps to protect its secrecy. The last intellectual property law that we're going to discuss is software licensing. The use of software generally requires a license that contains provisions relating to use, terms, and conditions. When you buy a piece of software, you are not buying the intellectual property. You're not buying the code. You're not buying the right to modify it. You are buying the right to use it, subject to specific terms and conditions. There are 4 categories of software licensing: freeware, shareware, commercial, and academic. And within each of these categories are specific types of agreements that are legally enforceable, including master agreements and end-user license agreements, often referred to as EULAs. Master agreements are sort of the broad terms and conditions. End-user licenses are very specific. You generally have to agree to the end-user license when you are doing the actual install. It's very common in the end-user license agreement that the publisher will declare extensive limited liability resulting from use or installation of the software. And since EULAs are considered a contract, they can be used to extend the provision of applicable copyright laws. Software piracy is really the exact opposite of software licensing. Software piracy is defined by the Software Protection Association as the unauthorized copy or distribution of copyrighted software. So here we have software that's been protected, and individuals or organizations in some unauthorized manner are copying it or distributing it. Piracy does include copying, downloading, sharing, selling, or installing multiple copies onto personal or work computers. So perhaps an organization bought a server license, they bought one server license, but they install that on 3 servers. That's piracy. Perhaps your teenager decides to download some music that's copyrighted, downloads it without paying for it. That's software piracy. It is unfortunately all too common. It is definitely illegal. It really, really harms the creator of that intellectual property. The Digital Millennium Copyright Act, the DCMA, actually makes it illegal to create products that circumvent copyright protections, such as a license key. So you're not allowed to produce products that do that. Then we have computer crime that's not related to intellectual property, but is related to the use of a computer. So computer crime is a term that's broadly applied when a computer is used in the act of committing a crime. And they're divided into 2 categories. One type of computer crime is using the computer as a target of the crime. So we're attacking a particular computer, that's going to be considered computer crime. The other is when a computer is used as a tool or the weapon to commit a crime. So in either case, whether the computer is the target or the computer is the tool or weapon, that's going to be considered from a legal construct as computer crime, and it will be covered by various laws that are specific to computer crime. So there are 4 computer crime federal laws that you want to be familiar with. The first is the Computer Fraud and Abuse Act, and that relates to unauthorized access to any federal government, financial institution system, or any system that's used for interstate or foreign commerce. Given that our systems connect to other systems all over the world, it's very easy to make an argument that almost any system is actually used for interstate or foreign commerce. The second federal law is the National Information Infrastructure Protection Act of 1996, and that's really the primary federal anti-hacking statute that's used in prosecution. The Wiretap Act relates to unauthorized interception of digital communication. The Electronic Communications Privacy Act relates to unauthorized access or damage to electronic messages in storage. So starting with the Computer Fraud Act, that's unauthorized access to systems. Our National Information Infrastructure Protection Act deals with hacking. The Wiretap is unauthorized interception of digital communications, and the Electronic Communications and Privacy Act is unauthorized access or damage to electronic messaging. These are the 4 key U.S. federal laws that are used by prosecutors. So then we move over to cybercrime. And cybercrime certainly is an area that as an information security professional, you are going to come face to face with on a very regular basis. Cybercrime is just this very broad term we give to criminal activity that involves the internet, a computer system, a computer network, or technology. And examples are very broad. They include data theft, data exfiltration, data modification, a privacy violation, denial of service attack, command and control activity, and distribution and use of botnets. All of those are examples of cybercrime. Think of it as just a broad term or a category, where what we talked about previously with computer crime relates to very specific laws that are used to prosecute, in many cases, cybercrimes. One of the really scary things about cybercrime is that cybercrime in general is a fairly low-risk, high-reward venture. That in most cases, the chances of getting caught and/or getting prosecuted, successfully prosecuted, for cybercrime is fairly small, and that there's a great reward to be made. So it tends to be low-risk, high-reward. You want to remember that as the motivation for cyber criminals as they're coming after your systems. If you're wondering why they're breaking the law because it's fairly low risk. I would expect that over time we will see stronger laws that deal specifically with cybercrime and that will make it easier to prosecute and harder to get away with these nefarious acts. So let's do a lesson review. Intellectual property law includes patents, copyrights, trademarks, trade secrets, and software licensing. Remember that intellectual property is something that is created. We use patents for an idea that can be produced. We use copyrights for an expression of an idea. We use trademarks for a marking. We use trade secret law to protect anything that we need to keep confidential inside the organization. Intellectual property law includes patents, copyrights, trademarks, trade secrets, and software licensing. We use patents to protect something that can be produced. We use copyrights to protect an expression of an idea. We use trademarks to protect markings that identify an organization or a service. We use trade secret law to protect secrets that are important to the organization that need to not be disclosed. And we use software licensing to express the terms and conditions of use of the software. We also talked about software piracy, which is the illegal copying and distribution of software that is being used in violation of license agreements, or in some cases not even ever being paid for. We talked about computer crime, which is when we use a computer either to commit a crime or it's a target of a crime, and the 4 federal laws that relate to computer crime. And we talked about this very broad category of cybercrime. So let's go into our lesson 1.6, Match the Meaning. I want to make sure that you understand the terms intellectual property, patent, trademark, copyright, trade secret, software piracy, computer crime, and cybercrime. So go ahead and put me on pause. Go ahead and match those meanings right up. Come on back and we'll see how you did. Let's match up our 1.6 terms. Intellectual property is an original creation. A patent protects the owner of an invention. A trademark protects a recognizable icon. Think Coca-Cola. A copyright protects the expression of an idea. A trade secret protects proprietary business information. Software piracy is unauthorized use of software and includes copying and distribution. A computer crime is when we use a computer in a crime or when a computer is the target of a crime. And cybercrime is a broad category that describes malicious, fraudulent, or intentional acts that happen on the internet or with using a computer or in a digital infrastructure. So let's take a look at our CISSP exam tips for lesson 1.6. You want to remember that IP laws generally require action on the part of the IP owner to obtain protection. They either need to put a symbol, you need to do a registration, or with trade secrets, you need to have been actively protecting the competence of those secrets. Computer crime is when a computer is used in the act of committing a crime. Computer crime can also be when the computer is a target of a crime. And cybercrime is criminal activity that involves the internet, a computer system, a computer network, or technology. It's a very, very broad category. It's not a legal category. The legal category is computer crime, but cybercrime is the category we use to describe all of that activity. Thanks for joining me for this lesson, and I look forward to seeing you in the next.